Our last topic is also a very, very interesting topic because it relates to the founder's perspective. It is my great privilege to introduce to you two experts from Nivalion. First, Mr. Lucas Macedo. He's a senior case manager at Nivalion. Lucas is admitted to the Brazilian and Portuguese bar and was an in-house attorney for several years with multinational groups in the Latin American energy sector. Mr. Simon Knupfer is a case manager at Nivalion and a Swiss qualified attorney. He worked for the permanent mission of Liechtenstein to the United Nations in New York, and he's also a well-renowned, he worked also for well-renowned international law firms such as Schellenberg Wittmer in Zurich, Switzerland, and Wilmer Cutler, Pickering, Hale and Dorr in London. Please take it away, gentlemen.
Many thanks for the very kind introduction, Adolf. Well, I would like to welcome you all to today's presentation on ESG claims from a funder's perspective. My colleague Lucas and I are very happy to talk about this increasingly important topic, which is also close to our hearts. Now, I would like to kick it off by saying that until recently, the focus on ESG litigation has been mainly on public interest claims and not commercial litigation. Well, this is mainly due to two factors. First of all, these legal claims were aimed at setting judicial precedent and amend the law. And second, of course, also because of the very high costs of commercial litigation. And as you all know, NGOs and similar actors are limited in terms of funds, so they focused on public interest litigation, where costs are to some extent controlled because, for example, the risk of adverse cost awards is rather reduced. Well, at the same time, commercial actors contribute a lot to many of the challenges we face today, and corporate ESG requirements differ around the world. And in addition, commercial litigation offers, unlike most of the public interest claims, a return on the investment. So that's why third-party funding has set foot in the field of ESG litigation. Third-party funding also contributed to the rapidly increasing number of ESG-related claims against corporates. So this might be why the head of the climate litigation lab in Oxford has made this quote where he said that for-profit climate litigation is a huge game changer. Now, in the next 25 minutes, I and my colleague Lucas will discuss why and to what extent litigation funding is actually such a game changer. I would like to kick it off with the basics of litigation funding, just to make sure that we're all on the same page. And then my colleague Lucas will discuss the ESG claims, recent trends in this field. We will then focus on the main part of our presentation, mainly the benefits and downsides of funded ESG claims and the criteria funders apply when assessing such ESG claims. Well, what is actually third-party funding? A funder provides funding to cover the costs of litigation and arbitration proceedings, and in return receives a reimbursement of its costs and a share of the proceeds, but only if the case is successful, which means funding is non-recourse. If the case is not successful, the funder loses its investment and the claim holder still doesn't have to pay anything. Maybe a word about what third-party funding isn't, or at least shouldn't be. A funder does not represent the claim holder, so a funder is not a lawyer representing the claimant, and the funder does also not give legal advice. This is also why funding is in line with the lawyer's duty to remain independent, and even the funder's right to be informed or to stay informed over the course of the proceedings does not change that fact. So consequently, the funder should not control the way the proceedings are conducted. But of course, as always, there are different approaches in this regard, and some funders have a more active approach than others. Now, when we look at the clients that are interested in third-party funding, we see on the one hand, corporate clients with well-capitalized corporate clients, and on the other hand, private clients with limited resources. Especially in the field of ESG litigation, we also see that NGOs and law firms that represent individual clients request funding. Now, when we look at these different stakeholders, you might already guess that funding has or serves different purposes. When we look at the well-capitalized corporate clients, funding is more of a, I would say, risk and cost management tool, while when we look at individual claim holders, funding simply grants access to justice because funding allows the claim holder to litigate, which would otherwise not be possible. When we look at the areas of law, well, it's pretty clear funding is actually possible in all areas of law. Especially when we look at ESG-related claims, that's an important fact because ESG claims often touch upon several different areas of law, maybe even at the same time, so that's an important factor. Now, you can imagine funders are not interested in every case, so a case must fulfill certain criteria to be fit for funding. First of all, I should say that funding is actually possible at any stage of the proceedings. So that could be pre-filing, in the middle of any instance, or even at enforcement stage. Talking about the specific criteria, the most obvious criteria, I would say, is probably that the case should have good prospects of success. But also the ratio between the budgets on the one hand that is needed to litigate and the potential proceeds on the other hand is an important factor. Duration, of course, is another aspect. And finally, the enforceability, because a judgment or an arbitral award must be enforceable, not just anywhere, but at least in one promising jurisdiction. So not just with regard to ESG claims, it can be said that funders fund about 10% of the requests they get, just to give you a general idea. Now, when we look at the funding process, so how does a claim get funded? It all starts with a funding request from the lawyers or the party that actually seeks funding. The funder usually then requests some high-level information on the case and the parties involved to conduct a conflict check. And once that is cleared, the funder checks on a, I would say, very high-level basis whether the case meets its investment criteria. For example, a lot of funders require a certain amount, a minimum amount in dispute. So the funder would have a look at that. The parties typically then sign a non-disclosure agreement before the whole case file is submitted to the funder. For the preliminary case assessment of a funder, the lawyers provide the funder with a statement of claim, provided that's already available, or they simply draft a memorandum. And such a memorandum would typically contain, first of all, a summary of the facts, including, of course, some key exhibits, and also a first legal analysis. The funder then tries to come up with a preliminary commercial offer. We at Nivalion call that term sheet. So I think on the slide, the term is term sheet. Well, for doing that, the funder requires additional information on the budget, but also on the expected timeline until final resolution, which of course means also enforcement. Now, by accepting this term sheet, the claimant agrees to a period of exclusivity. And during this period, the funder conducts a full-fledged due diligence. It remains in contact with the lawyers, provides them with DD requests, but funders often or mostly also rely on the expertise of external DD experts simply to, just address or get a review of the most pressing questions. Now, by the end of the exclusivity period, the funder must decide whether it wants to fund the claim at the pre-agreed terms or not. Well, if so, the parties enter into this so-called litigation funding agreement, or LFA. And if not, of course, the claim holder is free to consider other funding options. When we look at the proceedings, well, as I said before, there are different approaches with regards to the funder's involvement during the course of the proceedings. Just to give you an example, we at Nivalion, we have a rather, I would say, hands-off approach. So we remain in close contact with the lawyers and also offer our assistance, but we do not interfere in the proceedings. One aspect we hear a lot of questions about is the so-called pricing. It's actually a very good question, mostly because there is no easy answer, because funders apply different pricing models. However, they all have in common that at the outset, the funder would first look at the required budget and see or looks whether the ratio between the budget and the expected proceeds is good, meaning at least 1 to 10, because otherwise it may be that the funder keeps the major part of the proceeds and not the claim holder, especially if the proceedings last relatively long. When we take a look at the success fee, so what the funder gets in the end, the basis is, of course, the proceeds that can eventually be recovered. When we look at the actual calculation, there is a number of factors relevant. For example, the claim value, the budget, duration, and of course also the money that has actually been invested by the funder. Now, the success fee is then typically calculated on the basis of a time-dependent multiple that could be on the funds provided or committed. But sometimes the success fee can also be defined simply as a share of the proceeds in the end, or even as a combination of these two approaches. When we look at the so-called waterfall, which is the sequence in which the money is allocated to the different stakeholders, it is typically agreed that, first of all, the funder receives the reimbursement of its actual outlay, followed in a second step by its success fee, what I've just described before. And finally, in the end, all the remaining proceeds, they go to the claim holder. And with that, I would like to hand over to Lucas to discuss the ESG claims.
Fantastic, Simon. Thank you so much. You only make it an even bigger challenge to follow such intriguing, such exciting, to use Adolf's expression, presentations. Thank you very, very much. So yes, yeah, ESG claims. I mean, I'm not gonna even try to define the term, as we have seen such incredible presentations, really from Annette at the beginning, really showcasing the extent, the impressive reach of these terms, but also the counterpoint by Leonardo, trying to bring in some definitions. So I'm not gonna enter that discussion, but it is true that in the last 20 years, even less than 20 years, since the ESG expression first came in UN's Who Cares Wins report, the ESG movement really came from a corporate social responsibility initiative to a phenomenon. And it represents today over $30 trillion in assets under management, either deemed or labeled. That's another discussion, but there's no way of that the finance market would stay away from this trend or this discussion. And in that sense, of course, this has also been the case for litigation finance. I would like to just look at these claims as largely super individual claims that are based on either the violation of ESG standards or commitments by states and companies. But the most important definition here, I think, is in terms of time that they address. So would they be addressing past violations, or are they addressing future, or both? Typically, past violations can only be addressed through financial compensation, right? So as a means to diminish the damage suffered by individuals and affected communities. Otherwise, the forward-looking claims, they would present a much more strategic or policy shifting perspective. Typically, this would be injunctive reliefs, as we call, like obligations of doing or not doing under a civil law perspective. Either way, these claims, they're all an embodiment of UN Sustainable Goal number 16 of peace, justice, and strong institutions. Now, bringing this a little bit into practice, there are some hurdles that potential claim holders may face when they are trying to push forward ESG claims, or even to consider bringing ESG claims. And the first hurdle, of course, is information. It's very common that stakeholders or affected parties may not be aware that their rights have been violated, especially when we're talking about complex violations, as we heard today, for instance, in the supply chain, path, or even human rights violations. Sometimes violations may not look like violations, but as we heard just now from Harold, in terms of modern forced labor, that's a very ongoing definition, for instance. So that's the first hurdle. The second hurdle is really organization. It's not only important to know that you have been affected, but also to organize, to band together, to come together, and with that, move as a coherent group. And this is also a hurdle that affected parties may face. And the third element, and the most obvious one, is really the cost, especially when we're talking about class actions. Look at the UK. Any CAT action the costs can skyrocket for a number of reasons, either because we're simply talking about very complex matters. That's why we have such incredible experts here with us today, but also because this may take a significant evidentiary toll, long hearings and so on, which end up making it very costly and sometimes very tough for affected parties to bring these important claims about. So let me bring you just very quickly a few examples. And this is by any means, this is not by any means exhaustive, but some examples or some cases that we may look in terms of ESG litigation and funding of these claims, right? So environmental claims are really the most evident ones. We're talking about cases dealing with climate change, biodiversity, pollution, and they may have, say, a more indirect nature. For instance, we have a famous class action against rail operators that were overcharging passengers, right? In this sense, the environmental aspect here is the right to affordable public transportation, right? This is fundamental in reducing carbon emissions. Also, we have very direct cases like the RWE against Germany. And most recently, the Holcim case, now here before two courts. Really, ESG litigation has come to our doorstep. And these cases tend to bring to apportion liability for the direct consequences. For instance, the rise in sea level. So they want to hold in this particular case a major carbon emission liable. And these cases, as Annette said at the beginning of her presentations, they have been growing at an immense pace. We have at least 2,000 claims that have been really cataloged, and as the Guardian article, a recent Guardian article said, 2023 is poised to be a watershed for climate litigation. Moving to the social element, in here we first think of human rights, work safety, diversity, and inclusion discussions. They are, of course, true and vital to give teeth to, for instance, the supply chain vigilance regimes that we heard about today, either the German one, the French law of vigilance. They would mostly fit with the social definition. Another very interesting example, and I say that as a Brazilian, is the two collapse, the two dam collapses being litigated in the UK. So that case is interesting from an accountability point of view of having wrongdoers sued at their home courts for events occurred abroad. But also it would be within the social element, other aspects that we may not think about immediately as ESG, for instance, patent litigation. Patent litigation, because as a disincentive for big companies that simply can try to take away inventors' properties without paying royalties and licensing rights. Of course, these claims have an important role to protect the inventive activity, right? Then the last element, the G element, and one of the most interesting one, is the governance aspect. And here, I really emphasize the complementary, the interdependent law enforcement system that we have. So from regulatory bodies to justice prosecutors, competition authorities, consumer associations, NGOs, even shareholders, they all play a role in trying to curb in really effective curbing acts of mismanagement, corruption, greenwashing. As we have heard from Gillian, the case filed by ClientEarth versus KLM, it's a good example of claim against misleading and false statements. And of course, the very, very recent case against the Shell's board of directors. I think that's a very sophisticated claim, because the premise is that ClientEarth, as a shareholder of Shell, goes on and say that they would be infringing the UK Company Act by leaving the company exposed to the risks that climate change poses to Shell's future success. So it's really Shell's profitability that's at stake, right? So very interesting example of governance litigation. We can go on to the next slide, please. Simon? Yeah. Okay. I'm going to talk about now the benefits of litigation funding in ESG claims. Of course, the most obvious one is really taking on the costs, right? This does not remove only say an impossibility of a case ever being brought, but also shifts the risk to a professional entity that that analyzes and the risks of these claims and bring them forward. Of course, the informational and organizational aspects are deeply important. Again, the funder can either help directly or indirectly by, for instance, running book building campaigns, bringing stakeholders together into a coherent group, either forming, for instance, in Netherlands, a stichting, an association, an SPV, and so on. There are then, of course, funder will not be, as Simon said, funder will not be able to bring all the funding requests into reality. And typically, I have to say, funders tend to be very picky, which limits limits the cases that are being brought to very meritorious ones. So the first element, of course, is prospects and predictability of success. We heard today Leonardo explaining about how these claims may be speculative, and I have to agree with him to a certain extent, in the sense that there may be, yes, very speculative claims, and to that effect, I have to say that funders are not that keen in making new law because it's less predictable. And of course, many of these claims, they will deal with novel issues, right? But even when we don't have, say, landmark decisions, even when we don't have yet case law set, there is there is hope. There is say what keeps these cases going, at least internally, is the discussion of causation. So how do we determine and how do we apportion liability for damages? So in that field, the so-called attribution sciences are helping very much this evidentiary gap. This has been the case now, for instance, in the RWE case before German courts. Then funders will look at the enforceability of these claims. Mostly we have been seeing big defendants being brought to the courts, and of course they, in principle, they have ability to pay, and this may have been so far an issue, but still the funder will always like to have at least one clear enforcement path ahead in one promising jurisdiction to avoid and any defendant trying to leverage a minuscule settlement. And then we have quantum, and quantum and budget are intertwined, and not only from a technical financial perspective, but also from an ethical point of view. We always talk about this 1 to 10 rule ratio, meaning that the funder ideally would put forward one, say, 1 to 10 in the sense that if a claim is, for instance, involves 10 million euros, the funder would fund at the maximum would be $1 million, because this is to guarantee that the funder will never receive a majority of the proceeds. This is a tenet, and I would say an ethical tenet for professional litigation funders. Then we have duration. Duration it can be a very tricky element, because sometimes defendants may choose to settle very strong cases quickly, right? Maybe to avoid PR issues, maybe to avoid setting case law. But on the other hand, we also see defendants trying to really litigate matters to the very end, exactly not to give away a precedent in terms of conduct. And sometimes we have a mix of both scenarios, especially take, for instance, the Dieselgate litigation, where Volkswagen quickly settled in the US, then took many years to do the same in the UK, and still fights these claims in European Union. Of course, they will consider strategical aspects such as discovery in the US that can be very harmful to a company, how long the potential litigation would take, how much is at stake. So this again really highlights the importance of having professional funders on board, and very, of course, very good lawyers that may be able to consider all these prospects. It is much more than only the merits of a case, right? Then we come to the downsides of litigation funding. And of course, the obvious downside that we have is proceeds will be shared. And again, if the funder was not diligent at the very beginning there, when he was assessing a funding a funding request, they may find themselves in a situation where they would take a share of the proceeds that is not, where the funder is not comfortable at, the claimants are not comfortable, and it really, in my view, this really can hurt the sustainability of the industry as a whole. And this reputational risk should always be considered by the litigation funder. That is not to say litigation funding is the only way forward, right? Litigation funding is not a panacea, and even litigation itself, this is one tool of trying to change policy, trying to change it in a good manner. I mean, change the world, really. Again, the exciting times that Adolf said. There are many other possibilities, NGOs, pro bono legal support alliances, even state funds. Now we have the example of New Zealand and Canada setting funds to bring ESG litigation. They play already a role and will continue to do so. And this system is absolutely interrelated, because for a funder to watch, to observe the market, of course, as a part of it as well, but observe the precedents being set, and seeing more and more successful claims, this will only increase likelihood of settlements, and also a larger amount of funded claims. So this were the thoughts that I would that I wanted to share, and then Simon would close the package. Thank you so much.
Yes, to just briefly conclude and summarize what we have discussed and heard today, I would just like to start again with the funding basics. Well, the funder assumes the cost of litigation and arbitration proceeding on a non-recourse basis, which means if the case is not successful, the funder loses its investment. Well, then the funder receives as a success fee a multiple on the invested or committed capital and an additional share of the proceeds. We also saw that the funder does not, or at least should not, control the way the litigation or arbitration proceedings are conducted, but of course the funder does want to be kept up to date during the course of the proceedings. Looking at ESG claims, we saw that most ESG claims were, until recently, strategic claims. That means claims that were aimed at changing the behavior in the future. But these days, the claim holders also look at the past and claim for damages, of course, also with the side effect of changing future behavior as well. Now, these claim holders face challenges when it comes to connecting with other potential claim holders, the organization of a claim, and most obviously, of course, the costs of litigation. And this is exactly where litigation funding comes into play and helps to overcome these hurdles. But before a funder does so, it would typically look at the usual criteria that were mentioned by Lucas, for example, the ratio between the budget and the potential proceeds. The duration must be good, and of course, the prospects of success. And exactly this predictability issue, that might be an issue for a funder because ESG claims are novel claims and they have most likely uncertain outcomes. Looking at the downsides and benefits, well, of course, the most obvious benefit is that the claim holder is allowed to litigate. But on the other hand, we also have this reputational risk for the funder, since part of the proceeds will inevitably go to the funder and not to the party that actually has been hurt. When we look at the funding market in general, we saw that funders fund about 10% of the funding requests they get. So the funder will not be able to finance all potential cases that have merit. So NGOs and pro bono legal support will keep on playing an important role in this regard. Now, finally, taking a look in the future, I think it's fair to say that ESG will continue to play an important role in a funder's daily business, and not just when it comes to funding a claim, but also when doing a conflict check or even rejecting a claim, if there is, for example, evidence of wrongdoing such as corruption or fraud. Now, the ESG agenda has been described as a key driver of growth in litigation funding, and we've already seen in the last couple of years that the funding market has evolved. For example, some funders have explicitly positioned themselves as ESG funders, and others have set up funds explicitly just for funding of ESG claims. So finally, I think it's fair to say that this trend is likely to continue, since more successful claims will also make it easier to obtain funding for future claims. And with that, I conclude, and Lucas and I are happy to answer any questions you may have in the following Q&A session.